Just 2 days before his death, Stan Swamy had moved Bombay High Court challenging Section 43D(5) of the Unlawful Activities Prevention Act (UAPA), a provision Swamy termed illusory. The provision makes grant of bail virtually impossible under UAPA since it leaves little room of judicial reasoning. In the case of Zahoor Ahmed Shah Watali, the Supreme Court in 2019 confirmed that courts must accept the state's case without examining its merit while granting bail. In strings of rulings, however, courts have taken an alternative reading of this provision, emphasizing the right to a speedy trial and raising the bar for the state to book an individual under the UAPA. Let's look at what the provision says. The UAPA, enacted in 1967, was strengthened by the Congress-led UPA government in 2008 and 2012. The test for denying bail under the UAPA is that the court must be satisfied that a prima facie case exists against the accused. In 2019, the Supreme Court defined prima facie narrowly mean that the court must not analyze evidence or circumstances, but look at the totality of the case presented by the state. Section 43D(5) reads, notwithstanding anything contained in the code, no person accused of an offence punishable under chapters 4 and 6 of the Act shall, if in custody, be released on bail or on his bond unless the public prosecutor has been given an opportunity of being heard on the application for such release, provided that such accused person shall not be released on his bail or his own bond if court, on a pursual of the case diary or the report made under Section 173 of the Code is the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Look at what happens when court grants bail. When the court grants bail in Union of India, VKA Geneve in the January this year, a 3-bench of Supreme Court headed by Chief Justice N.V. Ramana upheld the grant of bail under UAPA when the accused had undergone incarceration for the significant period, even as it recognized that bail under UAPA was an exception. Courts are expected to appreciate the legislative policy against the grant of bail, but the rigors of such provisions will be melted down where there is no likelihood of trial being completed within a reasonable time and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Such an approach would safeguard against the possibility provisions like Section 43(5) of UAPA being used as a sole metric for denial of bail or for the wholesale breach of constitutional right to speedy trial, the bench held. The court noted that the accused Najib had spent over 4 years as an under trial and the trial was yet to begin. In February, the Bombay High Court granted bail to Telugu poet Varavara Rao, an accused in the Ilgar Parishad case along with Swamy, holding that bail under UAPA can be granted by constitutional courts purely on grounds of sickness and advanced age. Rao is 80 and had tested positive for COVID-19. Swamy is 84 and Jesuit priest suffered from Parkinson's disease and had tested for COVID-19. He was arrested in October last year. On June 17, the Karnataka High Court granted bail to over 115 accused charged under UAPA for the 2020 East Bangalore riots, holding that the NIA court had extended the time for investigation without hearing the accused. The court cited that the fundamental right to treated fairly under the law or the accused was violated as reason for granting bail.